The regressively right-wing Supreme Court of the United States has officially struck down President Biden's student loan forgiveness plan, infuriating every millennial and member of Gen Z in this country. Intrigued? Then click that like and subscribe, and enjoy the video. Well, folks, the day of reckoning continues with respect to judicial decisions from the United States Supreme Court. As many people predicted, the U.S. Supreme Court, which is populated by a 6-3 regressively conservative supermajority, they have decided to strike down President Biden's student loan forgiveness plan. Axios does a pretty decent breakdown that's relatively concise, so that's why I refer to them so often. And here are the cliff notes. Tens of millions of borrowers will resume monthly student loan payments after the Supreme Court ruled 6-3 on Friday that President Biden's loan forgiveness plan is unconstitutional. Before we go on, the reason that they will resume student loan payments is, you may recall that since President Biden took, actually, as a matter of fact, I'm pretty sure the student loan pause began under President Trump during COVID, and then President Biden continued that student loan pause for 3 years. When he announced this plan last year, he said that he was going to eventually begin student loan payments after the enactment of the plan. I think he targeted it for July of this year, July 2023. So that was always in the cards. But then to make matters more official, one of the terms of President Biden's debt ceiling negotiation with Kevin McCarthy earlier this month or late last month was student loan forgiveness definitely had to resume in July. So it was no longer just a promise that was ultimately up to President Biden, because prior to that, him saying that the student loan forgiveness would resume, it was essentially at his discretion, because he said that he was going to pause it, or that he was going to resume the payments once before and then changed his mind and allowed the pause to continue. But it's set in stone as part of the negotiation between Biden and McCarthy as part of the debt ceiling deal. I think it's actually written into the Fiscal Responsibilities Act. So this is inevitable. But anyway, why it matters. Borrowers who qualified for the relief plan would have been forgiven for loans up to $10,000 per individual borrowers who make under $125,000 per year, or $20,000 for Pell Grant recipients. Student loan relief had been blocked by court orders and been put on hold since November, months after the program's launch in August. Many borrowers said that the relief would help them financially plan for their futures, which is absolutely the case. Obviously, it was a partisan issue. The vast majority of Democrats and certainly progressives supported it. Virtually every Republican opposed it. Some moderate Democrats, like I think Joe Manchin and Kyrsten Sinema, also opposed it as well. About 26 million people out of more than 40 million eligible borrowers applied for student loan cancellation or had already provided enough information to the Education Department to be deemed eligible. And as Axios reports, this is just merely the latest blow that the Supreme Court has levied against the Biden administration's agenda. This is nothing new. They've done this before, and it was widely expected. Now, I will also point out, I can't remember if we did a video about this. I think we did, or maybe I just ranted about it on Twitter. The U.S. Solicitor General, who had to argue this case before the Supreme Court, even her conservative opponents, so people like Jonathan Turley, who is the Fox Propaganda Network's, go-to constitutional authority, and he's a professor at Georgetown, even he said, Elizabeth Prelogar is her name, she made a brilliant case, a brilliant defense of President Biden's student loan forgiveness that was widely celebrated by the vast majority of legal scholars, liberal or conservative. As a matter of fact, they were like, if it had been a debate, truly a debate, where it was just her versus her opponent, she would have won the day. She absolutely made an infinitely better case. I mean, it was just a spectacular performance, and I hope that President Biden, I don't know to what extent like a U.S. Solicitor General should jump immediately into a Supreme Court seat, but this woman is incredible. She would probably make a superb Attorney General in her own right. But yeah, that's where we are. Now, I want to point out that Justice Kagan, Elena Kagan, who was appointed by President Obama, she wrote a pretty blistering dissent. Of course, she and Justice Sotomayor, who was also appointed by President Obama, and then Justice Ketanji Brown Jackson, who was appointed by President Biden, they, of course, all dissented. And without reading every single line, I am actually going to read a few. One of the frustrating things about this case is the consensus was that, one of the parties involved was I think the party involved was Missouri, right? The state of Missouri, but they were actually granted standing on behalf of the state nonprofit called Mohila. So Missouri state statute allowed for the creation of this organization called Mohila as basically a student loan servicer. But legally, like if you look at Missouri law, legally, financially, Mohila and Missouri are separate. Mohila is not part of the Missouri government. It's a separate nonprofit that was simply created from state statute. And Mohila did not want any part of this lawsuit. So Mohila was used for standing to give Missouri the right to show up in front of the Supreme Court, because you have to have standing. You have to demonstrate that if you want to get before the Supreme Court, if you want to sue somebody, which Missouri is suing President Biden and the Secretary of Education, you have to prove to a judge that the person you're suing or the parties you're suing have harmed you, have actually directly harmed you, right? You can't just sue anybody for any reason. I mean, I guess you could, but it's not going to go anywhere unless you prove you have standing. So the means by which Missouri was granted standing, Mohila, they were like, we don't want any part of this. And so even during the oral arguments, and Prologer, U.S. Solicitor Prologer, who was arguing on behalf of President Biden and the student loan debt forgiveness plan of the Secretary of Education, she pointed out, and pretty much all the justices agreed, including Justice Amy Coney Barrett, that it's really hard to take seriously the idea that Missouri and Mohila are conjoined and that Mohila would be the means by which Missouri would have standing. And so Justice Kagan points this out. Under our usual standing rules, the separation would matter. Indeed, it would decide this case. The plaintiff, this court has held time and time again, cannot rest its claim to judicial relief on the legal rights and interests of third parties. As Mohila qualifies as such a party for all the reasons just given. That Mohila is publicly granted or publicly created makes not a whit of difference. When a government instrumentality is established as a judicial entity, distinct and independent from its sovereign, the law, including the law of standing, is supposed to treat it that way. So this case should have been open and shut. Missouri and Mohila are legally and also financially separate entities. Mohila is fully capable of representing its own interests and has always done so before. The injury to Mohila thus does not entitle Missouri, under our normal standing rules, to go to court. But the court defied those rules. Without that requirement, courts become forums for the ventilation of public grievances, for settlement of ideological and political disputes. Basically, the idea is that the requirement that a proper party, the party actually affected, can challenge an action ensures that courts don't overstep their proper bounds. Again, that's why it's important to have standing. You have to have standing to bring your case before the court. You can't just go to the court to complain about things. That's what your Congress is for. It's what your representatives are for. It's what your president's for. The kind of forum this court has become today. Is there a person in America who thinks Missouri is here because it's worried about Mohila's loss of loan servicing fees? I would like to meet him. That's a hilarious line from Justice Kagan. Missouri is here because it thinks the Secretary's loan cancellation plan makes for terrible, inequitable, wasteful policy, and so too for Arkansas, Iowa, Kansas, Nebraska, and South Carolina. And maybe all of them are right. But that is not what this court sits to decide. That question is more appropriately addressed to the representative branches and the broader public. So yeah, in the words of Justice Kagan, the Supreme Court, or at least the conservative majority, has overstepped its bounds to basically, become a political entity and put its thumb on the scales for a matter of policy when the party who is making the lawsuit has no standing. So once again, the Republican-appointed conservative Supreme Court has bent over backwards to accommodate a conservative interpretation. President Biden has spoken on this and has issued announcements, but we're going to do that in a separate video. Anyway, that's the news for student loan in the United States, specifically President Biden's student loan plan. And basically every progressive, every millennial, and every member of Gen Z is furious, and we'll see how it plays out in future elections.